And welcome back into Open Line. I'm Chuck Long here with Kevin Kennedy from the Kennedy Law Firm. If you're just tuning in, we're taking your legal questions. You've got a lot of them this evening, and we're really glad. I think you're helping a lot of folks this evening, Kevin, and a lot of people, like I said, with questions that help everybody just by the fact that they're asking those questions. So if you do have a question or a comment, all you have to do is call at 737-7587, and we'll get to as many as possible. We appreciate your patience. We're going back to the lines right now. Kai is on the line with us. Kai, good evening, and do you have a question or a comment for Kevin? You with us, Kai?
Yes, sir.
Yes, go ahead.
Yes. Oh, it's Ty.
Yes,
Ty, okay.
Mr. Kennedy, I've got a issue between my landlord and me. I'm disabled.
Yes, sir.
She has came in and thrown my Meals on Wheels food away. She's came in here, had her son come in here trying to bug me out of this my apartment. I pay my rent up from May to June.
Yep.
And she tried to serve me with just a little 3-day quit thing, and I've looked it up, but in the law it says you cannot be harassing a tenant to get them out. But she has totally bullied me, and like I said, throwing my Meals on Wheels away, food away, and taking the air conditioning out of the deck of the house. And I'm burning up in here. Like I said, I'm disabled. I'm an amputee. And I'm just wondering, do I have can I fight this or have a lawsuit towards her?
Absolutely. Here's the real world, and we feel for your circumstance, and thank you for the question. Landlord-tenant laws in Tennessee, it's also a crime if you harass anyone. So you can go to the district attorney and you could swear out a warrant. No one has to put up with harassment. The 3 days that you talked about, Tennessee law requires 30 days written notice. And so we hear that quite often at the law firm, that people just say, well, you got to be out tomorrow. Well, that's not the law. And so one of the great things about the legal services of Middle Tennessee, they take on so many cases fighting landlord-tenant. And I think we're going to see an increase in this as Nashville continues to grow and all the others. Then rents are going to be higher, and so landlords, some that would be unscrupulous, would try to double the rent, triple the rent, and move it out just for the money. But they're going to have to follow the law. And thank you, and I'm so sorry to hear about your circumstances.
Absolutely. So I think that's going to help you, Ty, that information. So we're glad that you called in this evening, and best of luck to you. All right, we're going back to the lines right now. So Carmus is on the line with us. Carmus, we're glad you're joining us. And do you have a question or a comment this evening? Are you with us, Carmus? Carmus, can you hear us?
Hello?
Okay.
Yes, go ahead.
You're on.
Oh, okay. So I have one question. When contacting a lawyer.
All right, so let's go on to, we're going to go to that next call. Charles is on the line with us. Charles, do you have a question or a comment?
Oh, yes, I do.
Okay.
Back in 1957, I was caught riding in a stolen car in Kentucky.
All right.
Okay, up to this date, the federal government wanted to have prosecuted me. They gave me 2 years probation. I done that. Now the government doesn't have no record of it. Kentucky don't have no record of it. That was in 1957. Only person that's holding it against me is called a felony now, which I didn't know about no felony back then. Is Tennessee. And they're holding it against me. I can't buy no firearm. I can't do this. I can't do this because they class me as a felon. I'll be 83 years old this year.
Wow. Well, the truth is, usually, even if they had given you 2 years probation, the difference between a misdemeanor is 11 months, 29 days, 1 day short of a year. And so that's considered a misdemeanor. When people plead and they have 2 years, then that's a felony. As a general rule, for years and years, once a felon, always a felon. And what you lost was your right to vote, and all kinds of things go along with it. And of course, in the background checks, are you a convicted felon? And it's a flag. And so it is true, one of the things he says, lots of times the states lose the records. There is no record of it, but somewhere it has shown up on the computer throughout the internet or something that Tennessee has picked up on that. And so, people move to other states and they never catch it.
Okay, great to know. So we appreciate that and appreciate your call. We're going back to the lines right now. So Tracy is on the line with us. Tracy, we are glad you're joining us this evening. And do you have a question or a comment for Kevin? You with us, Tracy?
Yes.
Okay, go ahead, Tracy.
Okay, I've just moved into a trailer park. It's nice, it's good, it's comfortable, I like it.
Right.
Except for the landlady.
Okay.
The thing is, it's like, I don't know if it was harassing or not, but she'll say, well, whose vehicle is this and whose vehicle is that, and says, if somebody's here, they need to start paying rent.
Yes.
And she always throws up, well, my attorney, and whatever. And, like she'll say, well, we've got cameras and we're watching. My neighbors have come to me telling me, well, you're behind in rent. And this person beside you is $1,700 behind. And the person behind you is, $500, and, this, that, and the other. And is that like something like a Privacy Act type thing?
Yes, and here's what I would say to that. You need to look at your lease and see what the landlord has said. If they say there's only 2 people and they must be on the lease, there can be no cars parked there except those who are registered to the lessees from the leaseor. They have certain contractual rights that they could express, but they need to be in writing. If it reaches a point of harassment and it's outside of that, for instance, if someone was slandering you, then that's a whole separate issue where you can bring a lawsuit and they would be responsible civilly. So you have to be careful on what you're saying about people, their reputation, and things of that nature. So you're right on target. It could be a violation of your privacy.
All right, so Tracy, we appreciate that question this evening. All right, back to the lines right now. So Michael is on the line with us. Michael, good evening, and do you have a question or comment for Kevin?
I just want to ask about disability versus Social Security.
Okay. Well, as a general rule, Social Security people qualify when they're 62 or they age out at 65.
Past that.
Yes. And so if you have a specific injury that is debilitating and you can get here's the whole thing. Everybody wants to get Social Security disability. I can't work. Well, that's wonderful, but you got to have a medical professional to say it. So they said, well, my doctor will say it. Well, when you send the letter in to get the report, he doesn't put it in writing. So the word to the wise is have a relationship with your doctor. Make it clear, doc, I cannot work, and this is permanent. That's what they want to know. Is it 100% disability? Are you disabled? And is it permanent? If so, then that would qualify you to pursue and get Social Security disability before that age.
All right, great to know. So, Michael, we appreciate that
call. Many cancer patients and amputees, and that's what happens there.
Okay, we are going back to the lines right now. Ty is on the line with us. Ty, you have a question or comment?
Yes, sir. I'm sorry. I need to ask a question about a felony. My dumb self had committed or said that I was guilty to something that I wasn't guilty to.
Yes.
And it's been over 13 some odd years. And is there any way that I might be able to expunge this?
Yes. One of the things you probably should do is talk to a lawyer privately. Tell what your case was. They've changed some laws where some of the felons out there can file to get them expunged and see what kind of programs are available. Also, you can always apply for clemency on that to the governor, and if it's a federal case, to the president. And it doesn't happen often, but it does happen. And so we go back to what I always said, you must advance your cause. A lot of people just give up, don't try, don't want to spend the money, don't want to pay a lawyer to research and advance and file petitions, but there are people who do. And I would encourage you to do that because your reputation and the felony will open doors or close doors for you for the rest of your life. The good point that you make, some people say, well, I just want to get out of this. I didn't do it. They did it, but I'd rather plead and stay out of jail and don't want to go to trial, too much stress. You should think long and hard, get the counsel of your lawyer and your family before you actually plead to something you're not guilty to.
All right, great information. Good to know that. So we appreciate that call, Michael. All right, actually that was Ty. Michael is on the line with us right now. So Michael, we appreciate you waiting on the line with us. It's up to you now to get that question or comment in. So do you have one for Kevin?
Yes, I do. I want to know if he will help me with an automobile accident that has happened, because I've been to a number of attorneys and they won't take it because my car wasn't tore up, but I was hurt in the accident of a semi-truck driver running into the back end of me on the expressway.
Yes. Well, the first thing that we need to do is talk privately and find out really what your doctor has said. When did you receive the treatment? And again, this is very much like that last call that we had a little earlier in the evening. The lawyers, they're saying, well, there's no damage to the car. How are we going to prove this? Because the insurance company is going to have every photo, and they're going to say a reasonable person couldn't have sustained these injuries from no damage to the vehicle or minimum damage to the vehicle. It's a challenge, but we'd be glad to talk to you and look at your paperwork and see. Thank you for calling.
All right, absolutely. All right, right back to the lines. Tracy is on the line with us. Tracy, do you have another question or a comment?
Yes, on about the lease. Sorry to bother you again.
That's all right. Go right ahead.
She had mentioned to me this month, I've paid up my rent and everything. I've never been, a month behind.
Yes.
But she had mentioned to me, well, this is the last month that I'm going to have, say-so over this trailer and my neighbor's trailer. Do you think I would have to, her son is taking it over, shouldn't I have to have a new lease?
Well, the whole question is, who is the owner, and does the owner, has he given that authority to a residential rental company? If they have the authority, that's their agent, and so they have the authority to change them one way or the other. So you really wouldn't necessarily have to have a new lease. It'd just be transferred to, and people do it all the time, from one real estate company managing to another real estate company managing.
All right, great. So we appreciate that, Tracy. So we're going back to the lines right now. Busy lines, and we appreciate your patience. Do you have a question or a comment for Kevin?
Yes. Hi, how are you all?
Great.
What I was asking, had a vehicle and it got repossessed, and the third-party creditor bought the loan, and now they're garnishing my check. Is there any way that I can get rid of that, get that out of their hands, some kind of way other than bankruptcy? I already filed slow motion pay, but I want to see if I can just, because I really don't owe them because they're a third-party creditor.
Okay. Well, the truth is, an ounce of prevention is worth a pound of cure. Anytime that someone has an automobile repossessed, you can count on it. They're going to sell it, what they have to do in a reasonably commercial sale. And that's when you can fight them before they settle all those issues on the finances. Once it goes down and they've got a judgment, sued you and have the judge, they can start garnishing you. Now, you're pretty slick. You already come up with the idea for a slow pay motion, and you will get some relief from that. The question is it enough? And if it's not enough, I would certainly, you can file a Chapter 13 bankruptcy anytime. So even if you filed a Chapter 7 or you filed a Chapter 13 previously, at any time you can go file a new one, and that would be considered an unsecured debt. They don't have any property to hold, and that would be one of the easiest ones to discharge if you had to.
All right. We appreciate that. And I tell you, our phone line's been very, very busy this evening. We appreciate the calls, the comments, the questions, giving a lot of great information, a lot of great advice.
Well, we appreciate all your questions, helping lots of people. We're glad to try to answer.
We do need to take a short break. If you're on the line with us, though, hang right there. We're going to be back with more on Open Line right after this.